In this video, we will learn about the fundamental rights in India, that is the fundamental rights that are provided to us by the Constitution of India. So the fundamental rights in India are enshrined in part 3 of the Constitution from articles 12 to 35, and these are essential guarantees to protect citizens' liberties and ensure equality. Inspired by global models like the US Bill of Rights, they form the cornerstone of Indian democracy, and we'll now learn about all the fundamental rights that have been provided to us by the Constitution. They are enshrined in the part 3 of the Constitution. So the first right is right to equality. That is this article. This is given in articles 14 to 18. So the right to equality, article 14 tells us that equality before the law and equal protection under the law. So we will first explain article 14, what article 14 is about. So article 14 is about absence of any special privileges in favor of any person, and the equal subjection of all persons to the ordinary law of the land administered by ordinary law courts. So this is equal subjection of all persons to the ordinary law of the land administered by the ordinary law courts, and absence of any special privileges in favor of any person. So there are two concepts here. First is equality before law, which is in article 14, and there is equal protection under the law, which is also in article 14. So first we will learn about equality before law. So equality before law is a British concept. It has been taken from the British Constitution. It is an element of the concept of rule of law, and it was propounded by A.V. Dicey, which was a British jurist. Then equal protection of laws, it is an American concept, and it tells us that the like should be treated alike without any discrimination. So these are two different concepts. One, equality before law, taken from the British Constitution, and the second one is equal protection of laws, which has been taken from the American Constitution. So equality before law, which has been taken from the British Constitution, it is an element of the concept of rule of law, and it establishes supremacy of law. Whereas the equal protection of laws, this concept has been taken from the American Constitution, and it tells us that the like should be treated alike without any discrimination. So this is all about article 14. Now we'll move on to article 15. So article 15 prohibits discrimination based on religion, race, caste, sex, or place of birth. So it tells us that there should not be any discrimination based on religion, race, caste, sex, or place of birth by state or by private individuals. So it protects us from the tyranny of the state as well as private individuals. So the state cannot discriminate against us based on religion, race, caste, sex, or place of birth, and the private individuals also cannot discriminate against us based on religion, race, caste, or place of birth. Some of the exceptions of this right are women, children, the people belonging to the scheduled caste, scheduled tribes, and other backward classes. So the government can provide for the positive discrimination to uplift these people in the society. The women, children, people from scheduled castes, scheduled tribes, other backward classes, etc. The state can do positive discrimination in favor of these classes, CST, OBC, women and children, for the further upliftment in the society, because they were downtrodden from the early times. Now we'll move on to the article 16. This is equality in public employment opportunities. So article 16 states that the state shall not discriminate against any citizen on grounds only of religion, race, caste, sex, descent, place of birth, residence, and it gives equality of opportunity in public employment. So this is what article 16 says, that everyone should have equality of opportunity in public employment, equality of opportunity in matters of public employment, and state shall not discriminate against any citizen on grounds only of religion, race, caste, sex, descent, place of birth, residence, etc. So this is all about article 16. Some of the exceptions of article 16 is that the state can provide residence to some people if they are public employees in particular states. It is available. And second one is OBCs, and third one is if people belong to the minority religion. And there are some certain exceptions are also there, that there is reservation, that is The reservation, 27% reservation is almost 27% reservation is given to the other backward classes. Scheduled castes get 15% reservation and scheduled tribes get almost 7.5% reservation. So these are the exceptions of Article 16. Then we'll move on to the Article 17. It abolishes untouchability. So Article 17 abolishes untouchability, and the practice of untouchability comes under the Protection of Civil Rights Act 1955, and this is all about it. Article 17 abolishes untouchability. No one should practice untouchability, otherwise he will be punished according to the rule of law or whatever provisions there are in if someone practices untouchability in the laws which are given in the Indian Constitution or the other CRPC, IPC which we follow. Then there is Article 18, which states that there will be abolition of titles. So earlier there were many titles and hereditary titles, the kings and the queens. There were a lot of princely states in India which had their own kings and queens, and these titles were hereditary. Some titles were also given to the nobles by the British. So these titles have been abolished, and the Article 18 states that it prohibits titles like Rai, Bahadur, except military or academic honors. Military or academic honors are allowed, but other types of titles are hereditary titles and nobility titles are not allowed. So Article 18 states that abolition of titles is there. These titles violate right to equality. That is why there has been an abolition of titles. So hereditary titles and nobilities were banned from adding these to their names or accepting titles. So, and any state cannot confer title on any individual, and no one can accept from any foreign title also without the permission of the president. So this is all about the abolition of titles. Then there is the right to freedom. Right to freedom comes under the Articles 19 to 22. So Article 19 gives us 6 freedoms, that is freedom of speech, freedom of assembly, freedom of association, freedom to form associations, freedom of movement, freedom of residence and settlement in any part of India, and profession, freedom of profession, occupation, trade and business. So these are all the 6 freedoms which are given to us by the Article 19 of the Indian Constitution. The freedom of speech, then freedom of assembly, that anyone can assemble peacefully in any area, freedom to form associations, freedom of movement, freedom of residence and settlement in any part of India, and freedom to practice any profession, occupation, trade and business. And freedom of speech includes freedom of speech and expression in any form. And then freedom of assembly includes freedom to assemble peacefully and without arms. Freedom to form association is there. Then freedom of movement is there, freedom of movement in any part of India, and then freedom of movement and freedom to move to any part of India. Then freedom of residence and settlement in any part of India, profession, freedom to practice any profession, occupation, trade and business. So these are all the 6 freedoms, and these 6 freedoms are subject to reasonable restrictions like public order and morality. And also there are certain restrictions like it should not compromise sovereignty and integrity of India, security of the state, incitement to an offense, or public order and morality. So this is all about Article 19. I will also tell you that freedom to assemble peacefully, unarmed, there should be no violence, and freedom to assemble it should be at any public place, not any private place, and it should not compromise the sovereignty and integrity of India, and public order and morality should not be compromised also. And movement, if we talk about freedom of movement, then freedom of some certain peoples like prostitutes and habitual offenders are restricted. And if we talk about freedom of profession, state can prescribe qualifications, state can state can let the people carry on any business or trade, and state can for freedom of profession, state can prescribe any qualification. And this is all about freedom of profession. Now we will move on to Article 20, as we have looked at the 6 freedoms of Article 19. So Article 20 is about protection against arbitrary prosecution, example double jeopardy, self-incrimination. So this talks about protection against conviction for offences, no ex post facto law, and no double jeopardy, and no self-incrimination should be there. That is, no ex post facto law should be there. That is, the law should not be applied from a date before when the law was enacted, and no double jeopardy means the person should not be punished twice for the same offense, and no self incrimination should tells us that the person should not be an evidence against himself. Person should not be forced to be forced to be an evidence against himself or herself. So this is about double jeopardy, self-incrimination, and no ex post facto law. These three are covered in Article 20, and it gives us protection against arbitrary prosecution and protection against conviction for offences. Now there is Article 21, right to life and personal liberty. So this is about Article 21. It is right to life and personal liberty, expanded by judicial interpretation to include right to privacy, right to education, and right to health. These are also included in Article 21. Right to life and personal liberty, expanded by judicial interpretation to include right to privacy, education, and health. Then we'll move on to Article 21A, right to free and compulsory education for ages 6 to 14. It has been earlier, it was not a fundamental right, but it was added in the 86th Amendment Act 2002. So this gives us a fundamental right. This gives the fundamental right to education for children between age 6 to 14 years, and compulsory education should be provided by the state to every child from 6 to 14 years of age. It is the fundamental right of those children. It is in Article 21A, and it was added by the 86th Constitutional Amendment Act 2002. And fundamental rights are enforceable in court of law. We all know that. So if it is violated, a person can move to the Supreme Court for its violation. So now we will move on to the Article 22. It states that there is safeguards against arbitrary arrest and detention, example right to legal counsel. So it Article 22 tells us that there is protection against arrest and detention, and there are two types of detention. First is punitive detention, and then there is preventive detention. Punitive detention is to punish a person for an offense committed by him after trial and conviction in the court. That is, a person has committed an offense, and punitive detention is done to punish a person for an offense committed by him after trial and conviction in the court. So he is detained, and after 24 he should be. And the second one is preventive detention. There is, in case of preventive detention, there is no trial or detention in the court, only intelligence information is there, and the person is arrested and detained. Maximum he can be detained for 3 months, and he should be placed before he should be given a legal practitioner, and he should be told about the grounds on which he was arrested. So the purpose of preventive detention is not to punish, but to prevent the person from committing the crime. So this is all about preventive detention and punitive detention, which is in Article 22, which safeguards against arbitrary arrest and detention. Article 22 also says that the person who is detained should be placed in the court in front of a magistrate in less than 24 hours or before 24 hours, and he should be awarded legal practitioner. He should be given legal practitioner to defend himself, and he should also be told about the grounds on which he was arrested. So this is provided in both punitive detention as well as preventive detention. And in case of preventive detention, there is no trial or detention in the court, but only intelligence information, and maximum the person can be detained for 3 months before he is produced in the court in front of the magistrate, so or a judge. In case of preventive detention, the purpose is not to punish but to prevent the person from committing the crime. Then we will move on to further fundamental rights. The right against exploitation. These are rights in Articles 23 and 24. So Article 23 prohibits of traffic in human beings and forced labor and beggar, that is unpaid labor. So this is what Article 23 is about. It prohibits traffic in human beings, beggar, other similar forms of forced labor, bonded labor, etc. So this is Article 23. These are the right against exploitation. So the Article 23 prohibits human trafficking, forced labor and begar and any other form of such labor, that is unpaid labor or bonded labor. It protects us against them, against these things. And then we'll move on to the Article 24, that is bans child labor under age 14, exceptions for family enterprises. So Article 24 says that there is prohibition of employment of children in factories, etc. For between 0 to 14 years of age, there should be no work given to them, and 14 to 18 years, the adolescent should be given no hazardous work, should be employed in no hazardous work. So Article 24 states that there is prohibition of employment of children in factories and hazardous works, etc. 0 to 14 years, the children should be not employed, and between 14 to 18 years, that is the adolescents, can be employed, but no hazardous work should be given to them. They cannot be employed in any hazardous work. After that, there is right to freedom of religions, which is from Articles 25 to 28. The Article 25 states that freedom to practice, profess and propagate religion subject to public order, health and morality. That is, a person living in India is free to propagate, practice and profess any religion he wants to, and the state shall not interfere in professing, propagating or practicing the religion that the person wants to, and unless and until it is the person is damaging someone's health or morality, or is an issue, there is an issue with the public order. It also states that the person should propagate good religious message and things to other people. So the person should propagate good religious message and things to other people. That is what it is. And Article 26, right to manage religious institutions. So Article 26 states that there is freedom to manage religious affairs and religious institutions by by people belonging to any religion as well as minority religions. So, and Article 27 states that there is no compulsory religious taxes. So freedom from taxation for promotion of a religion. It states this. And Article 28 restricts religious instructions in state-funded schools. So freedom from attending religious instructions in state-funded schools. So there's in state-funded schools there should be no religious instructions given to the students. There are three cases in this. That is, there is freedom from attending. A person studying in a school has the freedom from attending any religious instruction. Firstly, due to the Article 28, and it is a fundamental right, and it specifies three types of institution. First is the state institutions, that is the public institutions or state-funded schools. So in state-funded schools, there should be no religious instructions. And if this in case of the institutions which are administered by the state, there can be religious instructions. And in case of private institutions or aided, it is voluntary, that they can give instructions or they cannot give instructions also. So in case of state institutions, there is no provision of it restricts instructions in state-funded schools. In case of schools administered by the state, religious instructions can be given, and in case of private institutions, it is voluntary. That does, if the school wants to give any religious instruction, it can give, or if does not want to give, then it cannot give. Then there is cultural and educational rights in Articles 29 and 30. Article 29 protects minority languages and cultures. It protects the interests of the minorities, their script, language and distinct culture. That is what is in Article 29. It protects the interest of the minorities, their script, language and distinct culture. Then there is Article 30. Minorities can establish and administer educational institutions. So it gives the right of minorities to establish and administer educational institutions. And that is what it gives. That is what the fundamental right states, that the minorities have a right to establish and administer educational institutions of their own. And then we'll move on to further articles. That is Article 31. Now Article 31 was a fundamental right, that was right to property, but it was repealed and replaced by the 44th Constitutional Amendment Act in 1978. Now Article 300A, which is not a fundamental right. So now Article 31, that is that was right to property, is not a fundamental right. It is a legal right under Article 300A. Earlier it was a fundamental right, but it was repealed by the Constitutional Amendment Act 1978, and now Article 300A is a legal right, which is not a fundamental right. So right to property is not a fundamental right. Article 31 is not there. So we'll move on to Article 32, right to constitutional remedies. That is Article 32. So Article 32, right to constitutional remedies. It is the power to issue writ after filing of writ petition for the enforcement of any of the fundamental rights. So Article 32 confers the right to remedies for the enforcement of the fundamental rights of an aggrieved citizen. It is a part of the basic structure of the Constitution and cannot be abridged or taken away even by the means of a constitutional amendment. President can suspend the rights to move to any court during national emergency. Okay, so Article 32 states about this, and Dr. B.R. Ambedkar termed this the heart and soul of the Constitution. So there are different kinds of right to constitutional remedies. It has the power to issue, the courts have the power to issue writ after filing of writ petition for the enforcement of any of the fundamental rights. Article 32 confers the right to remedies for the enforcement of the fundamental rights of an aggrieved citizen. It is a part of the basic structure of the Constitution and cannot be abridged or taken away even by the means of Constitutional Amendment Act or constitutional amendment. President can suspend the right to move to any court during national emergency only. And so there are different kinds of writs, and Article 32 is the Article 32 allows the citizens to approach the Supreme Court to enforce fundamental rights through writs, and there are different kinds of writs. So they can approach the Supreme Court under Article 32, and they can also approach the High Court under Article 226. Under Article 226, High Courts can issue writs for the enforcement of fundamental rights as well as ordinary legal rights within its territorial jurisdiction. And under Article 32, the Supreme Court can issue writs within its territorial jurisdiction. So there are different kinds of writs. We will learn about the writs in a different video. There are different kinds of writs like habeas corpus, mandamus, prohibition, quo warranto, and certiorari. This requires a different video for them to explain, because it is a deep topic and it has a deep explanation and deep meaning. So we will just wait for the next video, and I will explain it to you all the writs in the next video. Till then, this is all about the fundamental rights which have been provided to us by the Constitution of India from Articles 14 to Article 32, and there are two other articles, Article 12 and Article 13. So Article 12 defines state, that is central government, parliament, state government, state legislature, statutory and non-statutory bodies, local authorities, and these all come under the state. And Article 13 states that laws should be consistent with or in derogation of fundamental rights will be considered null or void. So Article 12 defines state, and all the different institutions which come under the state are the central government, parliament, state legislature, statutory or non-statutory bodies, local authorities, panchayats, municipalities. All these comes under the state. And Article 13 states that all laws inconsistent with or in derogation of fundamental rights will be considered null or void. So this is Article 12 of 13. These are not the fundamental rights, but fundamental rights are from Article 14 to Article 32, which I have explained. And last one was Article 32, right to constitutional remedies. So now these are the key features of the fundamental rights. These are the notes. You can go through them. This will be helpful to you in your exams. Enforceability, restrictions, non-citizens, suspension. So we'll just take a look at them. Key features of fundamental rights or enforceability: they are directly justiciable. Courts can strike down violating laws, and if a law violates a fundamental right, courts can strike them down. Restrictions subject to reasonable limits, example national security, public order, etc. Non-citizens don't get Articles 14, 20, 21 applied to all. Article 19 is exclusive to citizens. So in case of non-citizens, they get only Article 14, 20 and 21 applied to everyone, and Article 19 is only exclusive to citizens of India. That is six freedoms, right to freedom. If you are not a citizen of India, then you don't have right to freedom. Suspension rights except Articles 20 and 21, that is the right Article 20 is protection against conviction for offences, and Article 21 is right to life and personal liberty can be suspended during a national emergency. These are all the amendments and judicial interpretations. 44th Amendment 1978 removed the right to property. Article 31 as a fundamental right, reclassifying it as a legal right under Article 300. I have told you before. Then Keshwar and Bharti case 1973 established the basic structure of the Constitution, preventing amendments that alter the Constitution's core principles. And there are other landmark cases like Maneka Gandhi versus Union of India 1978, expanded Articles 21 to include procedural fairness. Then Navtej Singh Johar 2018 decriminalized homosexuality under Articles 14, 15, 19 and 21. And Shaira Bano 2017 case struck down triple talaq as unconstitutional. Now recent developments are right to privacy recognized under Article 21 in 2017, Justice K.S. Puttaswamy versus Union of India. These are all important landmark cases and you should remember them. And Sabrimala Temple Entry Case 2018, Supreme Court allowed women's entry, balancing religious practice with gender equality. So the conclusion is that fundamental rights ensure India's commitment to democracy, justice and inclusivity. While they are not absolute, judicial activism has continually expanded their scope, reinforcing their role in safeguarding individual dignity and social progress. So we have completed all the fundamental rights in this video. Hope you found this video informational. These are the rights from Article 12 to Article 14 to Article 35, or Article, you can say that Article 12 to Article 35, enshrined in Part 3 of the Constitution. So we'll hope you found this video informational, and I'll see you in the next video.